President Trump was told by the Attorney General that he is in the Jeffrey Epstein files. He was told he was in the files 2 months ago, and then last week said, no, he wasn't. He was. This was during a briefing on the findings of the Justice Department's review of the documents related to Epstein. That's according to sources familiar with the discussion. Those sources said the Justice Department's review found that the files appeared to include several unsubstantiated claims that they determined not to be credible, including those relating to Trump. Bondi also raised in the meeting that several names of other high-profile figures were mentioned, the official said. And it's worth noting that being mentioned in the files does not in any way indicate wrongdoing.
Hey world, Adam is here. The top law enforcement officer in the United States just walked into a courtroom, signed her name on official documents, and admitted to committing federal crimes. This is not a hypothetical. This is not a political accusation from opposition operatives. This is Attorney General Pam Bondi putting her signature on paperwork that legal analysts now say could send her to prison for the rest of her natural life.
Tough questions for Attorney General Pam Bondi from the House Judiciary Committee. She is facing harsh criticism for her department's handling of the Epstein files. Now, this comes after some personal information of Epstein's victims was not redacted in the released files. In Bondi's opening statement to the House Judiciary Committee, she defended her department, saying it did the best it could to protect their identities in the time frame allotted by the law.
We've released more than 3 million pages, including 180,000 images, all to the public, while doing our very best in the time frame allotted by the legislation to protect victims. And if you brought us a victim's name that was inadvertently released, we immediately redacted it.
What we are witnessing is nothing short of a constitutional earthquake. Bondi didn't make a simple paperwork error. She didn't commit a minor procedural mistake that can be corrected with a polite apology. She allegedly attempted something that one legal scholar described as attempting to bend space and time.
Now, while most of those tough questions about the Epstein files were from Democrats, Bondi also faced tough questions from Republican Thomas Massie, a co-author of the Epstein Files Transparency Act.
So, I have several questions for you. Who's responsible? Are you able to track who in your organization made this massive failure and released the victims' names? Are you able to track who it was that obscured Les Wexner's name as a co-conspirator in an FBI document? Do you have that kind of accountability?
I believe Wexner's name was listed more than 4,000 times within 40 minutes. You asked me a question. Within 40 minutes, Wexner's name was added back.
Within 40 minutes of me catching you red-handed.
She tried to retroactively fix unconstitutional prosecutions by backdating documents, fabricating authority, and covering up violations of the Appointments Clause that had already poisoned cases against Trump's political rivals. And now the legal system is preparing to eat her alive. Let me walk you through exactly what happened because the details are devastating. According to court filings covered extensively by legal news outlets, Bondi is accused of unlawfully appointing a prosecutor to handle politically sensitive cases targeting Trump's opponents. The problem? That prosecutor wasn't properly appointed under the Constitution. The Appointments Clause in Article 2 has specific requirements for how federal officials must be put in position. Those requirements exist for a reason. They are checks on executive power. They ensure that people wielding federal authority are properly vetted and legitimate. When defense attorneys started raising Appointments Clause challenges, pointing out that the prosecutor bringing cases against their clients lacked constitutional authority, Bondi faced a choice. She could acknowledge the error, drop the flawed cases, and reassign them to properly appointed prosecutors. That would have been the ethical path. That would have been the lawful path. Instead, according to the filings, she chose to cover it up. Bondi allegedly signed documents after the fact, backdating them to make it look like the prosecutor had been properly appointed from day one. She attempted to retroactively ratify an appointment that was constitutionally dead on arrival. But here is the problem that every first-year law student understands. You cannot cure an appointments clause violation retroactively. The Supreme Court has made this crystal clear. If an official was not properly appointed at the time they took action, those actions are null and void. Period. You cannot go back in time and breathe life into a corpse. DOJ attorneys opposing Bondi in these cases called her out explicitly. They filed documents stating that her attempt to retroactively bless these indictments was unauthorized and constituted what they called a telling indication that the government knows the original actions were improper. That language, telling indication, is legalese for she just admitted she knew there was a problem. Think about the implications. Bondi is the Attorney General. She is supposed to be the person ensuring the Department of Justice operates within constitutional boundaries. She has spent decades practicing law. She served as a state attorney general. She understands the appointments clause. She understands that you cannot fix constitutional violations with after-the-fact paperwork. But she tried anyway. And that attempt, that conscious decision to cover up rather than correct, is what transforms this from a legal error into a potential federal crime. Now let's talk about what specific charges could land Bondi in a prison cell for the rest of her life. First, obstruction of justice. When you attempt to cover up constitutional violations in ongoing legal proceedings by backdating documents and fabricating authority, that fits the federal obstruction statutes perfectly. The law is broad and covers any corrupt effort to influence, obstruct, or impede the due administration of justice. Backdating documents to hide constitutional defects in criminal prosecutions is about as corrupt as it gets. Second, abuse of office. Using your position as Attorney General to improperly pursue political opponents with constitutionally defective indictments is a textbook abuse of power under federal law. You are wielding the authority of the United States government not to pursue justice, but to target enemies using legally invalid processes. Third, conspiracy to deprive rights under color of law. This is 18 U.S.C. Section 242, and it is serious. If Bondi worked with others to pursue prosecutions they knew were constitutionally invalid, they were depriving those defendants of their constitutional rights while acting under government authority. That is a federal crime with significant prison time attached. You might be thinking, okay, those are serious charges, but life in prison? Really? The answer is yes, really. Each of these offenses carries maximum sentences of up to 20 years. Obstruction can get you 20 years. Deprivation of rights can get you 20 years. Abuse of office, depending on how it's charged, carries similar exposure. Now multiply that by multiple counts. If Bondi obstructed justice in 5 different cases, if she deprived 5 different defendants of their rights, prosecutors can bring 5 separate counts. 5 times 20 years is 100 years. For practical purposes, that is life in prison. And here is where her position as Attorney General actually makes things worse for her. Federal sentencing guidelines allow judges to impose enhanced sentences when defendants abuse positions of public trust. Bondi wasn't just any government employee. She was the top law enforcement officer in the country. She was the person Americans trusted to ensure the Department of Justice operated lawfully. When she used that position to cover up constitutional violations, she didn't just break the law. She betrayed the public trust at the highest possible level. Judges view that as an aggravating factor, not a mitigating one. The court filing that exposed all of this is devastating because it is an official record. It's not a leak. It's not an anonymous accusation. It's a document filed in federal court that lays out in detail what Bondi did, when she did it, and why it was unconstitutional. And because it's part of the official record, prosecutors can use it. They can cite it. They can point to Bondi's own admissions as evidence of criminal conduct. She essentially did their work for them. She documented her own crimes in official filings. Now let's talk about the political dimension because it matters for how this unfolds. Bondi has been controversial since her appointment. Democratic lawmakers have accused her of politicizing the DOJ, of using federal law enforcement to target Trump's enemies and protect his allies. But those were always political accusations, allegations of improper motivation or bias. This is different. This is documented constitutional violations. This is admissions in court filings. This transforms the debate from political criticism to potential criminal prosecution. What makes this even more significant is the bipartisan nature of the outrage. Legal scholars across the political spectrum are saying Bondi's conduct is indefensible. Constitutional experts who normally defend broad executive authority are saying she went too far. Conservative legal voices who usually support the administration are saying you cannot retroactively fix Appointments Clause violations. When you lose support across the ideological spectrum, when even people who should be sympathetic say you broke the law, you know you are in serious trouble. Let me break down exactly why Bondi's attempt to retroactively ratify the appointment fails as a matter of constitutional law. The Appointments Clause exists to ensure that federal officials exercising significant authority are properly vetted through the political process. When an official acts without proper appointment, those actions are void from the beginning. They have no legal effect. You cannot later say, "We're ratifying that now, so everything is fine." The Supreme Court has rejected that argument repeatedly. The only remedy is to start over with properly appointed officials. Anything else is an end run around the Constitution. Bondi allegedly knew this. She is a lawyer, she was a state attorney general, she understands these principles, but instead of doing the right thing, instead of dropping the flawed cases and starting over, she allegedly tried to paper over the problem. She signed documents, backdated them, and attempted to make the unconstitutional appear constitutional. That is not a mistake. That is a choice. And in criminal law, choice equals intent. Intent is what prosecutors need to secure convictions. What happens next? Federal prosecutors will review the evidence. They will present it to a grand jury if they decide to move forward. Bondi could be indicted on multiple felony counts. She will then face a series of terrible options. Option 1. She can cooperate. She can plead guilty to reduce charges, testify against others who may have been involved, and hope prosecutors recommend a lighter sentence. Maybe she gets probation. Maybe she gets a few years instead of decades. But cooperation means admitting guilt and implicating others, possibly including people very close to the president. Option 2. She can fight. She can go to trial and hope a jury believes her explanations. But based on the strength of the evidence, based on her own admissions in court filings, that is a losing strategy. Juries do not look kindly on government officials who abuse their authority, especially the Attorney General. And if she is convicted after trial, judges typically impose harsher sentences than they would have if she had pleaded guilty. Option 3. This is the nightmare scenario. She gets convicted on multiple counts, and the judge imposes consecutive sentences that effectively amount to life in prison. The judge cites her position as Attorney General, cites the severity of the constitutional violations, cites her attempts to cover them up, and decides the maximum penalty is appropriate to send a message that no one is above the law. There is also the question of state charges. Some of Bondi's alleged conduct, the backdating of documents, the attempts to legitimize improper prosecutions may violate state laws as well. And here is the crucial point. State charges cannot be pardoned by a president. Even if Trump or a future president tries to pardon Bondi for federal crimes, she could still face prosecution at the state level. That creates additional legal jeopardy, additional pressure to cooperate, additional reasons for her to be terrified about her future. Think about the broader implications of this scandal. If the Attorney General can be prosecuted and potentially imprisoned for life for constitutional violations committed in office, that sends a powerful message about the rule of law. It says no one is above accountability, not even the top law enforcement official in the country. That matters because if AGs can break the law with impunity, if they can use their positions to pursue political enemies and cover up constitutional violations without consequence, then the entire justice system becomes a joke. But there is also risk here. The risk is that this becomes perceived as political persecution, that Trump's opponents use Bondi's prosecution to score points, that it deepens partisan divides rather than reinforcing shared commitment to constitutional norms. If Bondi gets a harsh sentence, especially life in prison, some people will see it as excessive, as punishment out of proportion to the crime, as vindictiveness rather than justice. Prosecutors and judges will have to be careful. They will have to ensure any charges and sentences are based on law and evidence, not politics or revenge. There is also the question of what Bondi knows and who else is implicated. She probably did not act alone. She probably received direction from higher-ups, maybe from the White House, maybe from other senior administration officials. If prosecutors can flip Bondi, if they can get her to cooperate and testify, she could implicate a lot of people. She could expose a broader pattern of constitutional violations. She could provide evidence for additional prosecutions. That is why the pressure on her is so intense. That is why life in prison is being dangled as a possibility. Prosecutors want her to be so scared of spending the rest of her life behind bars that she tells them everything. Here is the bottom line. Attorney General Pam Bondi admitted to unlawful acts in court filings. She tried to retroactively ratify a constitutionally defective prosecutor appointment. She backdated documents to cover up appointments clause violations. She used her position to pursue political prosecutions she knew were improper. All of this is documented in official records that can be used against her in criminal proceedings. She faces potential federal charges including obstruction of justice, abuse of power, and deprivation of rights under color of law. Each offense carries substantial prison time. If convicted on multiple counts with consecutive sentences, she could effectively face life in prison. This is a career-ending, life-destroying scandal, and it is just beginning. Prosecutors are reviewing the evidence. Grand juries may be convened, indictments may be coming, and Bondi has to decide. Does she cooperate and try to save herself? Does she flip on others and hope for leniency? Or does she fight and risk spending the rest of her life behind bars? Those are her options now, and neither is good. The Attorney General of the United States potentially going to prison for life is unprecedented. It is historic, and it will test whether the rule of law actually applies to the people at the very top. Stay tuned, because when charges come down, when Bondi has to make her choice, that is going to be breaking news with major implications for the entire administration. The justice system is about to prove whether no one is above the law actually means something.